Hi folks, you're with Tasseless today, your pushback channel, and thank you for joining this audio live stream. Now, I'd like to, in this essay, talk about really an extension, I guess, of one of the videos yesterday, but talk about the legal decisions and particularly the reasons for judgment and the rationale and the type of questioning that an activist judge will ask and decisions they make and the reasons for those, as opposed to a constitutional judge. Now, the globalists actively, aggressively work to appoint as many activist judges to positions on the bench as they can. It's one of their key methodologies of taking control of Western society and breaking it down and remodeling it in the image of the new elite class, turning us all into serfs and so on. Now, the fact that any group or cabal or organization would actively want ideological judges rather than legal or judges that act according to the law is just tells you what the globalists' intentions are. They're intending to destroy the West, because once you break down the laws and you remove the rule of law and due legal process, the application of law, you have in effect achieved a revolution without having to go into the street and blow people away. Once you have that arbitrary ideological control of the legal system, then you can pretty much do whatever you want and have the judges declare it as legal. So you have the facade of a legal system and the law and courts and so on, but it's an ideological court. It's there to achieve ideological ends, not to adhere to the law. And anyone that's sat in the divorce courts, if that's the epicenter, the shining example of ideological law at work. He's a straight white male. He is the oppressor. He's only a whisker away from being Hitler, a Nazi. She is the oppressed victim and is entitled to compensation by any fact or no, ideologically, of course. You dumb fuck. So the globalists actively want or aggressively want activist judges in all judicial positions. The appeal courts, the Supreme Courts, and so on. And they've as of sort of now 2023, they've mostly achieved their objectives. They've pretty much got control of the legal system in Canada and Great Britain. It's a close-run thing in some of the West European countries. Australia too, quite a close-run thing. A lot of activist judges here, but I don't know if they're in the total ascendancy, but they're certainly a very large minority, if they're not in an absolute majority at this point. And of course, the Supreme Court. Again, it was a close-run thing. If it wasn't for Trump, that Supreme Court would just be an ideological rubber stamp of the globalist policies and the globalist program. That's how close it came. So I just want to look at not only the reasons for judgment, but also the questioning and the rationale and the difference between a ideological judge and a constitutional judge. Now, if you look at say that recent case in the Supreme Court, or the Supreme Court heard it rather in the United States, the so-called Dobbs decision, which returned the abortion issue to the state legislature, which is where it really should have been and should have stayed. The Supreme Court action in the 70s to, in my opinion at least, a two-bit student lawyer that had prepared absolutely piss-poor documents. The decision to grant the abortion rights, in my view, was a political decision hatched in the back room by a court that decided in this instance will be activist, but they weren't necessarily in other decisions, or not back in the day at least. For some reason, somehow they were convinced that just go ideological on this, or politico-ideological. Now, in that Dobbs decision, where the deciding, the states could decide whether they would grant abortion rights, to what extent, what would be the term limit of a pregnancy, and so on. And so that was for the state legislatures, again, which I agree with. It's a decision for the people, not for the courts to make. The people through their elected representatives. So, but looking at the decision, the three leftist, hard leftist judges on the Supreme Court, they wrote a very emotional, very ideological, in my view, very emotional and ideological determination as to why it was a bad decision to do that. Now, they actually didn't specifically articulate why. They just sort of vaguely talked about rights and the oppressed and the entitlements and we have to protect the oppressed and all ideological stuff. There wasn't, in my opinion at least, there wasn't any reference to the law and the Constitution that I mean, there was a couple of sort of legal references, but they were breathtaking in it was a serious stretch to cite the stuff they did, and it to me was just a piece of insane chutzpah. But they had no argument against it, so they just went full bore ideological, emotional, and we dissent and hey girls, you go girl, let's dissent, and without really forming any cogent argument at all. Now that's the difference between a constitutional judge and a judge that in this case is just relying on ideology. In ideology, you can go in any direction you want because you just claim to say, well, we say this part is the oppressor, that party is the oppressed, therefore we make a decision in favor of the oppressed. But the degree of oppression, and if the party is oppressed or really oppressed, or any facts to support their oppressed, that's not relevant because you have ideologically already predetermined that. So effectively, the ideological law is prejudicial in the extreme. In fact, you cannot get a more prejudicial application of the law than the ideological law, which the globalists well know, which is why they want it and support it and why they love it so much. Because then they're not bound, the globalists are not bound by the law and the Constitution and so on. Because as long as we apply the law equally to all citizens, and as long as due legal process is applied again equally to all litigants, and the protections under the law and so on, then it's very hard for the globalists to launch their or to achieve their revolution. And they know that. They know that. As long as the law stands there strong and tall, it prevents the globalists from doing what they want to do. They know that, so the law has to go. Or alternatively, they've got to turn it into a whole lot of mashed potato that no one knows what's going on, and it ceases to function in any impartial sense. So it's very important that very, very important that constitutional judges are appointed and ideological judges are not. Now, I can look at any decision, when I read in the media or online or a newspaper or wherever, I read about a legal decision. I know just looking at the decision that an activist judge made that decision. I don't have to check or speculate. I know that an activist judge made that decision. And sure enough, when even I've never heard of the decision or the judge's name, even I know nothing about the case or the people involved in it, I know if it's an activist judge. No, I shouldn't be able to tell that, because every judge should be applying the law for fuck's sake, and the evidence and the Constitution and so on. So the judge, that's the judge's only job to do that. Now, in this case, or in these cases that I look at, I can tell straight away if an activist judge has been involved. No, I shouldn't be able to tell. Nobody should know. The judge's politics are utterly irrelevant. Not like these three Supreme Court justices in the United States that wear their ideological politics on their sleeve. They wave it around like it's some sort of fucking magic talisman that gives them, confers upon them extra rights and yet limits their responsibilities. I mean, it's insane to have infantile activists like that on the Supreme Court or any court is an utter fucking disgrace. Now, we also need to remember, once the laws are broken down and become ideological, then we are all of us unprotected, because the law, the law is a safeguard for all of us. It's completely independent of all emotional. They say facts have no concern for your feelings. Well, the law doesn't either. The law is on. This is the law. This is what the law means. And it may be subject to interpretation. But this is what the law means. This is the evidence you've presented. This is the tested evidence that stands up to being tested. And therefore, this is the decision of the court. Now, these activist judges go way beyond that and apply all sorts of ideological considerations they're not codified, that they don't exist in law. So the judges are arbitrarily applying these in court. Now, at the moment, it's the courts are favouring this group over that group and so on. But it means that if the court can be infiltrated by any other group, then it can then go chasing after anyone who's got red hair, or anyone who's got over the height of 5'6" or so. That they can go after any group they want. So when we really need to understand, one thing that really intrigues me is the amount of Jews, legal practitioners, Jews, many of them lesbians or gay, but lesbians in particular, that love this idea of activist law, that it should take into account ideological assertions and assumptions and speculations, and every decision should, because that's somehow some sort of miasma of social justice. So codified law, you can't do that to codified law. And that's why codified law is very important. Now, the codified law may need to be changed, and that's fine. Then you go to your elected representatives, and they then debate that and change those laws in the Parliament or the Congress or whatever. And I want to go back to some of the great travesties of justice over time, and this is to illustrate how important clearly codified law and the rule of law and due legal process are the most. The second we allow these things to be undermined, as we're seeing today, trashed by the every day in so many decisions, then we are, all of us, threatened. And this is something that these silly Jews, the Jews that should be at the forefront of saying, let's not let this happen, they're actually the cheer squad that are cheering on the trashing of the law. I just don't understand it. Learning the lessons from the past is absolutely critical for how we develop as a society. And at the moment, as best I can see, the lessons of the past are being recklessly and carelessly, if not casually, disregarded. Now, when the Nazis came to government in Germany, they, as we all know, were not so favourably disposed towards the Jewish diaspora. At first, the Nazis wanted to help the Jews leave, rather than be negative towards Jews. They wanted to really get all Jews to leave Germany. But because of the Great Depression and because other countries weren't interested in taking unqualified people of any type, let alone Jews, there were still 200,000 that were left in Germany. Now, not all these people were necessarily poor. Some of them owned like the corner delicatessen and these sorts of things. But the way the Nazis sort of went about going after the Jews was to, when Jews were in contest with Gentiles, I'll simplify this a bit. There was more to it, so I'm simplifying it here. The burden of proof for Gentiles to bring a legal case against Jews was lowered. So you could just make an allegation in effect. Again, I'm simplifying a bit, but you could just make an allegation, and that was enough to get the accused Jewish person or persons into court. Now, for the Jewish defendant to argue against this or to prove their innocence, they would be put under a very high burden of proof, or a much higher burden of proof than the Gentile was. Now, the burden of proof could be raised arbitrarily by the judge. So they could say, well, Mr. Goldstein, I'm going to require 5 witnesses from you to prove that you were not there at the time. And Mr. Goldstein says, well, as a matter of fact, I have got 5 witnesses. Yes, well, look, the court's reconsidered this. You need 10 witnesses. Oh, well, actually, I've got 10, Your Honour. Yeah, well, the court says you need 1 million witnesses. Haven't got 1 million witnesses? You're guilty, motherfucker. And that was how the game. That was an example of how the game was played. I mean, he did play other little games, like they'd 5 minutes before the court hearings due to start, they'd say, well, the judge can't make it into this town or village, so you have to go to another town or village. And maybe somebody would deliver a message to the house, and they've got 5 minutes to travel 20 miles to the next town where the judge is. And of course, they can't make it in 5 minutes. So the judge said, well, you never turned up. You never turned up. So that's a sign of your guilt. So you've been declared guilty and you have to pay this fine. And you have to. So, these were the scams that were tried. Other scams were used, such as backdating documents and putting data. So it was really designed to make it as difficult as possible for the Jews to win legal cases, and as easy as possible for cases to be brought against them. Now, no matter who it is, and whether you like people, don't like them, like this group, don't like that group, approve this group, don't approve, it doesn't matter. I would be the first to go out and protect. If Hitler was brought on trial tomorrow, or the devil was, Genghis Khan or Chairman Mao was brought on trial tomorrow, and there was a crowd saying, who gives a fuck? We all know he's guilty. Take him out the fucking back and swing him from the nearest tree. I would be the first to say, do not do that. You take these people, whoever it is, Genghis Khan, you take them into an independent court of law, not an activist judge, but a constitutional judge who will apply the law and the law only, and will listen to the evidence, and that it's tested under cross-examination and re-examination, and then a decision is made, whether it's judge only or jury. But make sure it is absolutely of the highest standard of legal probity, and that is how it should be done. Because once you do that for the person that you think is obviously guilty, why the fuck are we worrying about a trial? Once you do that for them, then everyone else is entitled to it. So there's no chance of this French Revolution or the Mao's fucking Cultural Revolution or the Soviet KGB running amok, where they just randomly grab folks and beat them to death and torture them or kill them, put them through kangaroo courts and so on. That's what we must protect at all times, from any direction it may come from. And that's a key thing. Now I want to jump to today, where the January 6th thing is a case in point. Now we make no comment of guilt or innocence here, but rather the process, and the fucking process is important here. We're talking about, certainly in my opinion, we're talking about arbitrary arrest on an unproven crime, arbitrary detention in spite of habeas corpus, and then people being dragged in front of activist judges, being browbeaten, effectively tortured, left in solitary for months at a time, browbeaten into accepting some sort of bullshit plea deal, and so on. Now, the burden of proof for innocence in front of these activist judges means that those accused have to prove their innocence to a very high standard of proof, whereas the state needs only present a very circumstantial situation, and next to no evidence. Well, Billy Bob was in Washington DC at the time, and we can say he was within 5 kilometres of the building, or that he walked past it, or something. So they've only got to prove that, and then say, well, that's it. We say Billy Bob was an insurrectionist. Now, a judge would, like a constitutional legal judge, say, okay, what evidence do you have that Billy Bob's an insurrectionist? He was in Washington at the time. Well, that's not evidence. You got to give me something. You got to give me something that he broke down a door, he assaulted a congressman, or he set fire to something, or he spray painted the inside of the Senate, or you've got to show me something here. And if you can't show me something, Billy Bob walks out this door right now. No, don't give me your bullshit. Show me your fucking evidence. Now, they couldn't do that in, and as far as I can tell, nearly all the instances, yet still the activist judge, put him in prison. Not a problem. Now, that's the same as in legal architectural terms, it's the same as the Nazis did, or it's the same as the Spanish Inquisition did when they were trying to find heretics. Now, the word heretic means, it comes from I think it's the ancient Greek word where it means to choose, or a choice you make. So the argument was you've chosen not to follow the path of Christ and God and that sort of thing. So it's your choice, therefore you are responsible, therefore you must prove that you're not responsible. Now, the arguments where you could prove that you weren't responsible are fairly limited. You say, well, I'm possessed by demons, and that kind of wouldn't work out so good for you either. But the Inquisition also reversed the burden of proof. So if someone alleged that you were communing with demonic spirits, then you had to prove you weren't, to quite a high burden of proof, whereas the alleger only needed to allege it. They weren't under the same burden of proof. And this was the failing of the Inquisition. Not that people weren't exonerated from time to time, they were. People with money were able to be exonerated at a very high rate, but this idea of a low burden of proof for the accuser, a high burden of proof for someone having to, and this reversal of burden of proof is something that's all over the legal system today, and activist judges apply it. And you see it in again, the divorce courts, where she can allege he's a child abuser, and that's it. He is. He's got to prove that he isn't, to a very high burden of proof. Whereas if he alleges she's a child abuser, then he has the high burden of proof to meet, and she has the low burden of proof to meet in rebuttal. Now, this is a reversal of the burden of proof, but also it lowers the standard of evidence and turns, once you lower the standard of facts and evidence, then ideology fills the vacuum. So these are the things that I think are concerning for all of us today. But just looking at the musings of the judges in the Supreme Court about the Dobbs decision, that abortion thing, which is treated by the left, who is desperately trying to gin it up into the end of the world as we know it and all that sort of stuff. When all it means is each state gets to make their own abortion laws. Just reading the Kagan and who's gone now from the Sotomayor and there's another one. They sound like gender studies students at some fucking bullshit university. Their reasoning is infantile and it's childlike and it's emotional, it's ideological, and that I'm aghast that people of that caliber are on the fucking Supreme Court or any court for that matter. But this is where we are with activist judges, and it's a scary situation. You've been a Tacitus today, your Pushback channel. Thank you for listening.